The broadcast is now starting. All attendees are in listen-only mode.
Hello, good afternoon, and many thanks for joining me. Welcome to the Next in Our 5 series of webinars. My name is Rebecca Davidson, and I'm an employment law partner at gunnercooke. Hopefully everybody who's dialed in can now hear me. This afternoon I'm going to be looking at top tips for negotiating terms of departure with senior executives. There is a facility to raise questions on your dashboard. Please do use that throughout the seminar, and I'll try to pick up any questions which arise during the presentation. Though I plan to cover any questions, I think, at the end, which will probably be slightly easier. The session should last about 30 minutes, and I will try to keep to that time. If anyone would like a copy of the slides afterwards, I'd be happy to email them across to you, so do just let me know. And the audio file will also be available on our website if you want to listen again, or if you want to forward it to any colleagues who you think might find it useful. So I've been advising businesses on negotiating terms of exit with senior executives for many years. And I also advise senior executives who are leaving their employment, so I have the advantage of being able to see things from both sides of the fence. During this session, though, I plan to focus on some of the key issues which HR departments and managers should be aware of before they start negotiating terms of departure with senior executives. Much of what I'm going to say is also applicable to negotiating with more junior team members, but I do find in practice that senior executive departures are often more complex. Usually, of course, they're on bigger packages, so the cost of getting it wrong can be considerable, but they're also often more sophisticated in their approach, and I find in practice that many senior executives will start to instruct lawyers from a very early stage as soon as they see that the writing's on the wall. So if they're all sort of lawyered up, then it's important that the business as well is aware of what the potential issues could be. Negotiations are often more protracted with senior executives as well, because there are other issues to consider, whether it's incentive arrangements or bonuses. And obviously, when considering parting company with a senior executive, one of the preliminary considerations for a business is often going to be what the impact will be on the business of that executive's departure. Now, that's something which applies regardless of seniority, but obviously is more exacerbated the more senior the person is. You need to look at what disruption will be caused by their departure and how best can that be minimised. And often that, I find in practice, will drive the negotiations rather than the potential legal claims which may result. And in some cases, the need to act swiftly in the case of a senior executive departure may actually outweigh the need to follow good employment practice. But I think nevertheless, it's a good idea to have an understanding of what the potential legal claims could be and what the consequences could be of parting company, so that that can all be weighed in the balance by the business or whoever's making the decision. Obviously, there's many reasons why a business might want to part company with a senior executive. There might be just a simple redundancy situation. It could be poor performance, or simply a personality clash, which actually in practice is something which seems to arise quite frequently. And I've seen the full range of situations, from those which are genuinely amicable because both parties are ready to move on and they just want to document it, right through to extremely acrimonious situations which result in litigation in an employment tribunal or even in the High Court when you're dealing with a bonus claim. And I think the trouble is, for people in HR and management, is that often it's quite difficult to predict at the outset which discussions are going to run smoothly and which are going to end up in litigation. And I think for that reason, it's always best to do a bit of planning before you start the discussion with the executive, and make sure that you've taken whatever steps you can to try to protect the company's position in case things unravel. In other words, don't assume that particular executive is going to deal with things in an amicable way, because they may not. When it comes to it. And I think some of the messiest departures I've seen in practice have resulted from a situation where the company has assumed that a deal will be done with the executive, but it turns out that the executive is more upset and litigious than they'd anticipated. And if the company hasn't taken steps to protect its position in case a deal can't be done, then that can be problematic. So what are the main risks? Well, I mean, again, it's fairly obvious, but the main risk of getting it wrong is that the company ends up facing an unfair dismissal claim, or even a claim for whistleblowing or discrimination, which it can't then defend or can't defend successfully because it's been negotiating with the executive but has forgotten to document on the record the reasons for departure, whether that's poor performance or redundancy or, as I mentioned, the personality clash, whatever the reason is. And some of the points which I'm going to cover in this session should hopefully help you to avoid things going wrong, and also perhaps give you some suggestions for things which you could raise in negotiations with the executive to help get a deal over the line. And since it's the 5 series, I'm just going to be focusing on 5 top tips to bear in mind when you're negotiating with those senior executives. So my first top tip is to make sure that you understand the difference between open and without prejudice, and then to deal with the right part of the negotiations under the right heading. Essentially, anything which is open is on the record. And that means that it can be disclosed in the event of any tribunal claim, and it can be referred to in a subsequent tribunal or court proceeding. So any discussions which you're having with the executive which relates to the reason for the dismissal, so whether that's documenting poor performance or going through a redundancy process, should usually be on the record. So that means it's open. And a discussion which is properly without prejudice, on the other hand, is off the record. So that can't be referred to in general terms in any future proceedings. And you should think about having without prejudice discussions with a senior executive if you're planning to pay them something which is over and above their entitlement to contractual notice and statutory redundancy where that applies. So, for example, to take a sort of fairly common situation, if you're planning to give an executive their 3 months notice, either pay in lieu or garden leave, but then to pay an extra £30,000 as a gesture of goodwill, provided that they leave amicably and sign a settlement agreement, then any discussion that you're having with the executive about that 30,000 or about the settlement agreement should be without prejudice, in order that it can't then be referred to in any subsequent tribunal hearing. And part of the reason for that is obviously to enable companies to have discussions with employees to try to settle any potential claims which they may have, without the company worrying that that's going to prejudice their legal position in the event of a claim. So, using my example of paying the executive 30,000, if that was on the record, then there could be a perception that the company is acknowledging that there has been an unfair dismissal or discrimination or whatever else may apply, but that they're trying to buy the employee out of a claim. So you want those discussions to be without prejudice so that they're off the record, so that you can have the negotiation without fear that it will result in any inference that there's been any wrongdoing on the part of the employer. For a discussion, though, to be properly without prejudice, it needs to meet certain criteria. And it needs to be a genuine attempt to settle a pre-existing dispute. That's really the critical, the critical test. The without prejudice rule itself could probably form the basis for a whole new seminar, and that may well be something which we come back to. But the headline point to be aware of is that a discussion can only properly be without prejudice once there's a pre-existing dispute between the parties. And that really prevents you from starting your without prejudice discussions too early in the process. So, for example, the fact that an employee might have issued a grievance doesn't usually mean that there'll be a dispute for these purposes. So if somebody brings a grievance, you can't then immediately assume that you can launch into without prejudice discussions about departure, because, of course, a grievance doesn't necessarily mean departure. So as a general rule of thumb, it's usually better to leave the without prejudice discussions until a bit later in the process, once some on-the-record discussions have taken place about the proposed reasons for the departure. And really the reason for that, as I mentioned earlier, is to give the company some fallback in case a deal can't be done. So in a redundancy context, this might mean leaving the without prejudice discussion until perhaps the second consultation meeting or even the final dismissal meeting. If you're going to have a without prejudice discussion with the employee, you need to make sure that they understand what's meant by without prejudice, and also that they agree to have a discussion on that basis. Usually senior executives will know what it means and they'll be happy to have that discussion because they want to know what they're going to get paid. But it is always worth just making sure of that. I just wanted to mention briefly as well that you can lose without prejudice protection if there's any what's called unambiguous impropriety. What that basically means is that employers can't say something on a without prejudice basis which is a threat or which is perceived as blackmail. So, for example, you can say, you're right, on a without prejudice basis, I agree that you're being made redundant because you're pregnant, and then expect that to necessarily be treated as being off the record. So you need to be careful what you say, even in a without prejudice discussion. I think in practice, one of the main mistakes which I see employers make is that they get so caught up in the without prejudice discussions and negotiation that they fail to have any on-the-record discussion with the employee to record a reason on the record for the dismissal. That may not matter if the without prejudice discussion is successful. So if you've got a situation where you make an offer to an employee, they accept the offer, they sign a settlement agreement, then this may not matter. But it's, as I mentioned earlier, it's really trying to make sure that in every case you've got something on the record just in case that this is one where the employee won't take the deal. So you need to ensure that you've got a potentially fair reason which is given for the dismissal. So, for example, redundancy or poor performance, and that you're following the correct procedure depending on what that reason is. So consultation meetings for redundancy, and perhaps giving warnings and an opportunity to improve for poor performance where that's possible. Usually I think it's best to view it as having as there being like a parallel process. So that at the same time as having open discussions about the reason for the dismissal, you're also thinking about the without prejudice discussions at an appropriate time in order to try to settle the dispute. And finally, I just also wanted to briefly mention pre-termination negotiations, which do come up from time to time. These were introduced, excuse me, a few years ago as an alternative to without prejudice discussions. The idea had been to simplify negotiations when an employee leaves and to make it less likely that any negotiations would be admissible in any tribunal proceedings. The main difference between pre-termination negotiations and without prejudice discussions is that there's no need for a pre-existing dispute. But my own view of these pre-termination negotiations is that they should really rarely be used, I think, for senior executives, because they're only effective where the only potential claim that that individual has is unfair dismissal. If there's any risk that that executive may have a discrimination claim or a whistleblowing claim or anything else, then you should be looking at without prejudice rather than pre-term negotiations, I think. So moving then on to the second top tip, which is to check the contract of employment. Now, that sounds pretty obvious, but it's surprising how frequently in practice I see a situation where discussions have started with an executive about departure, but nobody's actually gone back and checked the contract of employment. It's a pretty common mistake, and it's a pretty easy thing just to check before you start the discussions. The notice period obviously is one of the critical things to check. Check how long it is. Can you make a payment in lieu of notice? We call those pile-on clauses, I'm sure most of you know, but check if there's a pile-on clause. If there isn't a pay in lieu, but you pay in lieu anyway, then that's actually a breach of contract, and that can impact both the tax treatment, but also a consequence that people may not always be aware of is that if you terminate in breach of contract, then any restrictive covenants which you may have in the contract can fall away. So if you make a payment in lieu, but you've got no payment in lieu of notice clause, the restrictions can fall away unless you restate them in a settlement agreement at the end. Check in the contract as well if you're able to put the employee on garden leave. And then there's a sort of practical business point here, which is to check how long you actually need them in the business for, because as I mentioned earlier, you may find that these negotiations with senior execs are sometimes driven by how quickly they need to get out of the business, and then it's a quick case of working the legal arguments and the legal structure around what the business needs. Check for bonuses or commissions or any other incentives, and importantly, check what the dates are for those. I had a case once where an employee brought a grievance against a bank after discussions around departure had already started. And the bank was so busy dealing with the grievance that they missed the cut-off point for serving notice before a discretionary bonus had to be paid. So they ended up having to pay out a rather large discretionary bonus because they got so caught up in the grievance which the employee was bringing. So just make sure that you know the timings on any bonuses or commission payments, because that may impact the timing of a dismissal as well. Check too if the employee is also a director. If they're a director, you're going to need to make sure that they resign as a director as part of any departure. And you may also need shareholder approval for any compensation, particularly if you're paying something over and above contractual and statutory entitlements. Restrictive covenants. If you want them to be applicable, as I mentioned, you need to make sure that you don't breach the contract when you're terminating employment. You may want to restate them anyway in a settlement agreement if it's important, or make it a condition of a deal that the employee enters into restrictions if what you have in the contract isn't good enough. Sometimes when you go back and look at the contract of employment for somebody quite senior, you discover that their contract hasn't been renewed over the years that they've been with the business. So do take a look at that and just think about whether restrictive covenants need to be made part of any subsequent negotiation with them. My third tip then is to make sure that you've tried to look at the facts objectively and try to assess what the potential claims might be before you decide on any settlement proposal or settlement range. That doesn't mean to say that you need to think that the claims are necessarily going to succeed, but I think you need to think about it from the executive's perspective and what claims they may think that they have, which will give you an idea of what settlement range they may be looking for as well. As I've mentioned already, I think in some cases the commercial necessity of parting company with a senior executive quickly might drive the way that it's handled. But in order to assess the risk of taking that kind of action, I think you need to have an understanding of the underlying risk of a claim and also the value of that potential claim. And then once you've worked out the parameters of the claims, you can then think about what a sensible settlement range will be. As I'm sure most of you are probably aware already, there's broadly two sets of rights in the UK. So there are contractual rights and statutory rights which the employee will have and which they'll be getting advice on. Unfair dismissal is the most obvious one in a dismissal situation. Employees have to have 2 years service to be able to bring that claim. It's a loss-based remedy, so they can only recover for any losses that they've actually suffered as a result of the dismissal. And there is a cap on that compensation though, which I've put on the slide, which is just over 80,000. Plus a small amount for a basic award. Discrimination claims, you just need to think about whether there's any, has the employee raised any grievances? Is there anything that they've alleged during the course of their employment that may flag up the risk of a discrimination claim? Those claims, of course, are uncapped, but it is still a loss-based remedy. So again, an employee is only going to be able to recover for what their losses actually are. And in all of this, it's important. So, for example, if an executive already has another job to go to, and that job is of an equivalent salary, then actually they may not be able to, even if they had a strong claim, they may not be able to recover much because they haven't actually suffered any losses. Some other statutory claims to be aware of: the protective award for collective redundancy. That probably won't arise in many situations, but if you are dealing with a lot of redundancies, so more than 20 redundancies in a 90-day period, then be aware as well of the protective award which employees can claim, which is up to 90 days pay, but it's 90 days pay at their actual salary. That's not a capped one. So if you're making a large number of people redundant, you need to be aware of the protective awards and to make sure that you follow the collective redundancy process in order to avoid that. Whistleblowing, I just put that on the slide to be alert to any protected disclosures which the employee might have made. Again, it's sort of checking their personnel file, making sure that you're aware of any potential allegations that they've raised in the past which might lead that executive to say that the reason why they're being dismissed is because they've blown the whistle about something. Again, hopefully unlikely to arise very regularly, but it does come up sometimes in practice. Holiday pay. Generally, employees will be entitled to be paid for any accrued but untaken holidays as at the date of dismissal. So again, it's just being aware of what that calculation is. And statutory redundancy payment, which, as most of you probably know, is calculated based on a formula based on age and years of service, and that's subject to a weekly cap of £489. I think at the moment it's just changed. So those are broadly the statutory claims that you need to be aware of when you're thinking about what an executive might be claiming when they leave. Contractual claims are the other set of claims which they'll have, and those are, as you'd expect, broadly governed by what's in the contract of employment. So contractual notice period is the obvious one. Bonuses and commissions, any other incentive arrangements will be subject to their own rules, but you need to check what those rules are on termination so that you're aware of what the entitlement is for the executive. Contractual redundancy scheme I put on the slide as well. I think we used to see a lot more of those than we do at the moment, but some companies do still have a contractual redundancy scheme where, for example, they give the executive 1 month per year of service, or any employee 1 month per year of service in the event of redundancy. If you've got a scheme that is contractual, then you'll need to comply with that, although I think the majority of schemes these days are discretionary rather than contractual. So once you've thought about all of the potential claims that the executive may have, you then ought to be thinking about a starting and a closing settlement offer. In most cases, it's probably sensible to put forward a sensible proposal, but something that has a bit of room for manoeuvre so that you can then negotiate something. Particularly when dealing with senior executives, I think I find that they quite often want to feel like they've got a bit extra out of the company compared to what the original offer is. Alternatively, of course, you might just want to put forward a final offer, which is the maximum that the company is prepared to pay, and then stick to it. I think it's just worth thinking about the strategy, depending on the nature of the individual you're dealing with, what your usual practice is, but have in mind which of these two approaches you're planning to take before you start. Be aware as well when dealing with senior executives that many of them may well be familiar with your past practice. So I've seen quite a few situations where senior executives are not happy with the initial proposal because they know through their position, not through any breach of confidence, but through their position as a manager or a director, that they're aware of what other colleagues have been paid in the past. So although there's no legal obligation on a company to pay the same on a discretionary basis to everybody who leaves, if you're dealing with a senior executive who is aware of what other people have been paid, then obviously that's going to impact negotiations as well. So assuming then that you've reached a point with the senior executive where you have a settlement figure in mind, the next thing which I wanted to cover was the non-financial terms that you might be willing to offer the individual, because I think it's worth giving some thought to these beforehand, because actually from a senior executive's perspective, obviously what they're going to get paid as any lump sum is important. But in some situations, as important or almost as important can be some of the non-financial aspects of any deal, which may well help. If you're able to think about some of these in advance, it may well help to get a deal over the line. And most of these can be wrapped up in a settlement agreement, and I'll come on just at the end of this session to talk about settlement agreements in a bit more detail. A reference is something to think about, whether you're able to give something more than the standard reference. Think about what the reason is for the dismissal and who's going to draft the reference. Sometimes it's a good idea to get the executive to do the first draft of the reference, so you can see what they want you to say. Obviously, then there needs to be a sanity check to make sure that you're comfortable with what they've proposed. For any FCA regulated firms, obviously the reference obligations are different and much more restrictive. But do be aware that even for employers which are not in financial services, there is a duty to provide accurate information on a reference and not to make any negligent misstatements. And it's really for that reason that many businesses now take the view that they give just a very standard reference that just gives dates of employment and position, not much more than that. But when you're dealing with a senior executive, there might be some situations where actually agreeing a slightly longer reference, which gives a bit more detail about what they've done for you as a business, may assist, because actually that's often quite a big point for employees who are leaving. Similarly, an announcement, think about the extent to which you can involve the senior executive in the announcement about their departure. Often that's something that can be agreed and it can be attached to a settlement agreement so that everybody's basically saying the same thing about the reasons for departure. I think in practice, letting the senior executives have a say in the announcement and how it's pitched is often quite important to them to enable them to protect their reputation. So, for example, are you saying that they are leaving to pursue other business interests, or are you being more specific? You might want to think about thanking them for their contribution. Sometimes, obviously, it's appropriate to announce a replacement at the same time. I think these are all things that need to be thought through and then in some situations discussed with the senior executive so that they can feel that they've got some control or some input. Although, of course, at the end of the day, it's up to the business to make the announcement that they want to make. But I think enabling a senior executive who's leaving to be part of that process is quite useful when appropriate. Taxation of the payment. Again, most of you are probably familiar with the fact that currently, at least, we've got 30,000 tax-free for non-contractual payments. That includes statutory redundancy pay and can include any non-contractual ex gratia payment. Obviously, it's sensible to structure the offer in a way which makes sense from a tax perspective, so it's worth taking whatever advice you need from tax advisors to make sure that you're comfortable with the structuring of the payment. Usually notice monies will be taxed, although in some circumstances those can count towards the tax-free exemption. You do only get one £30,000 tax-free exemption though per executive per departure. So if for example you've got statutory redundancy and an ex gratia payment, you don't sort of get double counting, you can only have it once. Take advice on that, but make sure that it's structured in a tax sensible way. Restrictive covenants, I've mentioned these already, but actually it may be worth thinking as well about whether you're willing to relax them if it helps to get the deal across the line. I've quite frequently seen employers agree to release an employee from a non-compete restriction in order to get a deal done on a without prejudice basis, but provided that the employee agrees to comply with the non-solicitation of staff and non-solicitation of client restrictions, for example. So just give some thought to that. It's usually a point that the employee will raise, but no harm in thinking beforehand about whether all of the restrictive covenants need to be continuing or whether there are some that you could perhaps relax if it would help to get a deal done. And extending the benefits, again, this is something which comes up quite a lot in practice. Particularly with medical cover, if somebody's receiving medical treatment, you need to check with your provider, but you can sometimes extend the cover for an ex-employee to the end of the current insurance period without any additional cost. Depends on the provider, obviously you need to check that, but it's something that's worth thinking about, particularly for an employee who's receiving medical treatment at the date of dismissal. So moving then on to some more non-financial considerations. Think about whether you want to put the employee onto garden leave or to pay in lieu of notice. Doesn't usually make much difference in terms of the cost to the business, but can of course make a difference to the employee. Sometimes employees will want to receive a payment in lieu of notice, so they've got the lump sum, but they can then immediately start employment somewhere else the day after. From a business perspective, quite often, for the same reason, I guess, that the business wants to put them on garden leave, so that they're still employed but not actually providing services in the office, but to prevent them from joining a competitor straight away. In some situations, it may also be appropriate to ask the employee to work through their notice or to work through part of their notice. That's not very common for senior executives, but sometimes there will be a handover period, and you need that executive to be available. So you need to give them notice, but then have them still in the office for a month or two to hand over to the next incumbent. Company property, again, usually this will want that this will all need to be returned on termination, but it is worth thinking about whether you can offer as part of a deal any smaller items if it helps to finalise a deal. So quite frequently we have executives asking to keep their iPhone or to keep their laptop. In some cases, the issue for the executive is simply that they want to keep the number, and they need the company's help to transfer the number across to their personal account, which again is something just worth thinking about whether you can offer that. Outplacement assistance. I think that's particularly useful if somebody's been in the industry for a long time. They can get help with CV and interviews, but it can also include career coaching and things like that. Again, executives often find that quite useful. Other things to consider for a settlement agreement, a non-derogatory comments clause is quite a common one. That can be reciprocal. So in other words, the executive is agreeing not to make any derogatory comments about the business, and with some careful drafting, you can have a provision where certain members of the business agree not to make any derogatory comments about the executive. You need to be careful about having too wide an obligation on that one. But that can be particularly helpful, I think, where things have been acrimonious. If the business is worried that the executive is going to go off and badmouth them, or if you think the executive might be worried that someone will say something, that can be quite useful. Also, confidentiality. There's an opportunity under a settlement agreement to have not just a restatement of a confidentiality clause in the sense of keeping confidential any confidential information, but you can also require an executive to keep confidential the terms of the settlement agreement, which can be quite helpful if you want to make sure that if you've done a particular deal with that individual, but you want to try to limit the number of other employees who become aware of that deal that's been done. Ongoing assistance, that's another clause to think about in a settlement agreement. That enables you to require the employee to provide ongoing assistance in relation to any investigation or tribunal claim where the executive has knowledge which might assist. Sometimes that's a time-limited clause. I quite often see it just lasting for a year or two after somebody leaves. But the idea is, particularly for somebody in a senior role, they may well have some knowledge which you might need to rely upon in the event of whether it's a regulatory investigation or a tribunal claim. So that's worth thinking about asking for as well. So coming towards the end of the seminar now, I'm conscious that we're close to the 30 minutes. I've just got on the last slide a table which sets out advantages and disadvantages of settlement agreements. I do sometimes get asked whether it's necessary to enter into a settlement agreement. It can be a bit time consuming, but actually in the UK it's the only effective way to get an employee to waive statutory claims which the executive has, apart from a process which is done through ACAS, which is called a COT3, but that's something different. But having a settlement agreement is the only way to make sure that the employee won't bring any future claims against the business. It does mean that they need to take independent legal advice because they need advice to make sure that they fully understand the terms and effect of the agreement. And usually the employer will make a contribution towards the legal fees or sometimes pays it in full. But when you're dealing with senior executives, I think usually in most situations, particularly if you're paying them something more than their contractual and statutory entitlements, you want to make sure that there's a line clearly drawn in the sand and that you know that once they've left, they can't bring any future claim against the business. And if you want to do that, then the only way to achieve that is to have a settlement agreement. So you can see the advantages are longer than the disadvantages. I think in broad terms, it's going to be best usually to record it in a settlement agreement just to make sure that you've got that clarity and to protect the business against any future claims. That really is everything I wanted to cover today. I'm going to stay online in case there's any questions. I can't see any that have been raised so far, but I will stay online at the end in case anybody's got any. Or do feel free to drop me an email if you've got any questions after the session. And I wanted to mention as well that on the 14th of February, my partner Christine Oxenberg will be looking at 5 essential rules for directors, which is the next in the series, in the 5 series of webinars. So do look out for invites to that, and I'm sure that many of you will find it useful. And many thanks for joining me this afternoon. Okay, I can't see any questions which have come through here on my screen, so I'm going to close the seminar now, but if anybody does have any questions, do please just drop me an email and I'll come back to you separately. Many thanks.